Swayam Prabha. Digital India. Educated India.
Good evening viewers, this is Dr. Ashwini Siwal from Faculty of Law, University of Delhi, and I am here to discuss a very important issue and significant issue in the series called Law, Science and Technology. This is lecture number 17 of this series, and I am here to discuss with you the topic titled Information Assurance, the law in India. Well viewers, we in this series have discussed very fascinating issues like AI and law, like AI and IP interface. We have also discussed law relating to drones, we have discussed law relating to nanotechnology, we have discussed several exponential technologies and disruptive technologies and the law pertaining to those technologies. But today I am going to talk about information assurance law specifically in India, and in another lecture on this series we will talk about the law prevailing pertaining to information assurance in European Union and US, but this lecture predominantly revolves on the law in India pertaining to information assurance. Well, my dear viewers, there are certain things which I am going to cover in this particular lecture. I will discuss the existing legal scenario on information assurance. Well, I have written data protection because data protection is the field which is a broad field, and within it the information assurance falls or comes, or within its sweep information assurance comes. Your personal information is your data, and we popularly hear about data protection laws, or we popularly use the term data protection. We rarely use the word information assurance, but this is a word which finds its prominence, and it may also be interchangeably used with the data protection. Since data protection to some extent is you may say is restrictive, or its interpretational contours are restrictive, because it just relates to data, and data may be your information in any form, right. It may be biometric, it may be your health, it may be your banking data, it may be your educational data, it may be your very personal data about your individual health or etc. But when it comes to information assurance, any information, again it is in the form of a data, be it digitized or a non-digitized or maybe subsequently digitized, falls into the category of information assurance. So, we will see the existing legal scenario on data protection, wherein we will see what are the constitutional mandates in India, what are the contractual arrangements which we have been using in India to regulate the data or information assurance. Then specifically we will see the Information Technology Act of year 2000, because this is the basic act, or you may say it provides the basic structure on data protection, or for that matter on information assurance in the virtual space. Then we will see Right to Information Act, and we will also see what what are the laws and regulations pertaining to outsourcing of data, right, in India, and what are the incidents of misuse of data or its abuse by the BPOs or by multinational companies. We will also have a look at the Information Technology Amendment Act 2008, and finally the Digital Data Protection Act of year 2003, which is a recent development, which is the latest law on data protection, right. So, let us begin. Viewers, what is data? Well, the definition of data can never be straightforward. It is something which can never be defined in a one unilateral way. Data means something you give, you provide some information to somebody is called your information or is called your data which you have provided to someone. Sometimes intentionally, sometimes unintentionally your information is taken away. Then if we go by the legislative definition under the IT Act of year 2000, then it defines it as data means a representation of information, knowledge, facts, concepts or instructions. Well, when we read this definition, the first and the foremost thing is the representation of information, and that is why I have used the term information. The nomenclature of the lecture is information assurance, because data is what? Representation of information as per the definition provided under section 2O of the Information Technology Act. It means knowledge, facts, concepts or instructions which are being prepared or have been prepared in a formalized manner and is intended to be processed, is being processed or has been processed in a computer system or computer network, and may be in any form including computer printouts, magnetic or optical storage media, etc., or stored internally in the memory of the computer. So, any representation of information, knowledge, facts, concepts or instructions which are being prepared or have been prepared in a formalized manner, which are as an input processed in the computer system or in computing devices or stored internally in the memory of the computer, that is technically the data as per the definition provided under Information Technology Act. Since this act is pertaining to cyberspace, this act is pertaining to computers, computer networks, so it defines data only in the context of information technology as a medium. It does not define data which is outside the information technology medium, like your information which you have jotted down somewhere or shared by word of mouth with someone, or your information which you have provided on a paper, in a form, in the government forms, etc. That information remains outside the ambit of this act, that is called Information Technology Act. And this is one of the reasons that we had to bring the Digital Data Protection Act of 2023, which is more comprehensive, catering or encompassing or entailing even that data which is not a digital data, but subsequently it may be digitized or it may not be digitized. So, this is one of the shortcomings of the IT Act, which is why it was blamed as inadequate act so far as the data protection is concerned or information assurance is concerned in India. Well, now we know that physical representation of information in a manner suitable for communication, interpretation or processing by human beings or by automatic means is also called data. Any physical representation of information in manner, again representation of information is coming, that is why I have used the term information assurance, in a manner suitable for communication, interpretation or processing. So, any information which is suitable for communication, interpretation, processing in any way whatsoever under this act, in a computer medium, in a computer network, or by storing it in the computer or by processing it into the computer. But otherwise any information, communication or any particular you may say knowledge, fact, etc., which you share with somebody by writing it on a paper or by word of mouth, even that may be used, misused, processed, right, even that may be interpreted or even that may be communicated. So, that also is a data or that also is a information. So, some assurance is needed even on that information, but this act I am sorry to say that it does not cater to it, and that is why I said we brought a new act which is Digital Data Protection Act of year 2023, about which I will talk in great detail at the end of this lecture, but we will see the entire framework in the India on data. But the question arises, why data matters, why are we so concerned, why are we so worried about it, and what is whole a whole discourse and what is whole you may say chaos about data. The reason is the data matters because it is an information of individual, and it may be a sensitive information of an individual, it may be a health record or a medical record of an individual, it may be a patient's profile, right, and it may be a consumer trend, it may be a banking information, it may be anything for that matter, and all these things mentioned here have the potential of being breached, taken away, violated by anyone or free ridden by anyone for their unscrupulous purposes. That is why data matter. In fact, it is also said that data these days is new oil. It is considered equivalent to a oil. When we see, that our world has seen or witnessed the oil as one of such commodities which is very, very, very important, for any nation states. Even wars are fought and wars may begin, right, for gaining control over oil or gaining control over a commodity called oil. But now a war may be fought for gaining a control on our data, but this war, unlike that war or unlike a physical war, is more of a virtual nature than of a physical nature. Here in the computer medium, in the virtual space, data leaks do take place. Data is stolen, data is taken away without your consent, it is misused, it is processed in umpteen number of ways without your consent, and you never know when the collusion of several multinational and giant companies take place, and then your encrypted data also goes into the hands of those companies. They may use it for determining consumer trends, they may use it for causing some damage or harm, or determining the individual behavior or the behavior of the masses of a particular nation, and so on and so forth. So we need to be beware what we share. We should not share everything, but what is happening that in social media or in the age of social media, we are sharing everything. We are not confining anything, every bit of information about our life, about our personal life is getting shared with the public or is falling into the public domain, which may be misused, which may be processed for a wrong purpose, right. So we need to be aware what we share when it comes to data, or specifically about the sensitive personal data. Now coming to sensitive personal data, well, dear viewers, sensitive personal data as per the definition provided under rules of 2011 under the IT Act. These rules are called Information Technology Rules of 2011, and in elaborate sense these rules are called Reasonable Security Practices and Procedures and Sensitive Personal Data or Information, or you may also call them SPD rules, right, Security Practices and Procedures of sensitive personal data or information. So here sensitive personal data or information has been defined of a person as what? It relates to your password, or this is illustrative list as to what may be called sensitive personal data, right. It is an illustrative list. A password may be called your sensitive personal data or is a sensitive personal data. Financial information, bank account, credit card details, etc. are sensitive information. Physical, physiological and mental condition, even somebody's mental condition, that somebody is under depression, right, this is a sensitive information. So it must not be easily allowed to be used by anybody else. Somebody's physiological condition, somebody's physical condition, right, these are all your all your sensitive personal informations. Even sexual orientation of a person, whether a person is a gay or a bisexual or straight or what not, right, these informations are personal to the people. Medical records and history, like somebody is suffering from a particular disease, right, or somebody is say having some underlying condition, right, sexually transmitted disease or something like that. These are personal things or sensitive informations about the person. Even biometric information, which is your say iris, biometric, all these informations are what? Sensitive personal informations. And any details relating to above clauses as provided to body corporate for providing service is again sensitive information, and the body corporates should not process them beyond the purposes for which they are meant to be used. So what all comes under the gamut of data protection and what constitutes data protection? To conclude that, I will say that basically data protection is a set of privacy motivated laws. So there are a couple of laws, like Information Technology Act is one, then SPD 2011 rules, and then Constitution, contract law, IPC, and now the Digital Data Protection Act of 2023. These are basically privacy motivated laws or set of privacy motivated laws, including the policies and procedures that aim to minimize intrusion into respondents' privacy caused by the collection, storage and dissemination of personal data. There are certain legal safeguards used to prevent misuse of information stored in computers. It encompasses control, management, creation of basic rights and obligation, penalties and remedies in case of breach. So, these are, you know, I'll say that these are legal safeguards used to prevent misuse of information, control mechanism, management of data or information, creation of basic rights or obligations of the people, and then finally providing penalties in case of breaches or remedies in case of breaches. So, what are the factors responsible for trans-border data flow? So, first of all, we need to understand how is it important and why I have you know, brought it here, because you know, the trans-border data flow or trans-border data exchange is causing more damage, is deemed more harmful vis-a-vis to the data which is stored in our country by our domestic companies or by domestic corporates. When it comes to trans-border data, when the multinational companies do come here in India for doing the business, they definitely have to abide by the law of the land, and our law of the land up till now before 2023 has been very weak so far as the information assurance or data exchange or data flow, especially the trans-border data flow is concerned, because we did not have much regulatory framework in place except the IT Act and then SPD rules of 2011. It was only in the year 2021 we have brought a full-fledged omnibus legislation on digital data protection, and which basically even caters to trans-border data flow. So, what are the factors responsible? We all know that the world is a global world. There is a changing economic and you know, social and technological landscape. Globalization has reduced the territories. So, there is a ubiquity of data, data is everywhere. Role of the individual has changed in this global world. People are doing online activities using smart technologies, and they are you know, resulting into, and their activities, and this impact of globalization has increased in the volume of data flow, and global IP traffic has reached, you know, a very great threshold, right. So, this is the reason that, you know, there is occurring a trans-border data flow, or there is happening the trans-border data flow, but it used to be completely remain, you know, it remained unchecked or unaddressed, especially by the purview of the laws. There were some, you know, industry regulations privately brought, or some industry regulations or standards prevailing in India which used to address this concern, but there was no legislatively made law, or you know, there was no legislation as such which catered to trans-border data flow explicitly. So, what are the factors responsible for trans-border data flows? To understand the data involved in these statistics, well, I am skipping this is not important. Factor responsible for surge in trans-border data flow worldwide, fading of the international trade barriers. International trade is phenomenally increasing, and as it has increased, it has reached a different level altogether. The BPO or IT enabled services are you know, rampant. Phenomenon such as Web 2.0, 4.0 etc., they have also brought, you know, surge in the trans-border data flow. Then online social networking has become a major cause these days. It is becoming a major cause for the trans-border data flow. Then, you know, advanced search engines, right, where our information gets stored, and cloud computing is another issue. Then enhanced economic importance of data. Well, we all know that data is the new oil, and you know, every country tries to appropriate data, or you know, trans-border exchange is increasing, or its flow is increasing because of attempts to appropriate e-banking and e-commerce, right. Advanced analytical tools to generate economic value out of data, that is big data technique. These techniques are used to mine on the data, to extract and to, you know, process, reprocess it in several unknown or several complicated ways and complicated meanings. So, there has come a paradigm shift in handling of data. Well, since I have just explained to you that trans-border data is being exchanged and it is going to different countries, offshore locations have their servers, etc. Multinational companies have their servers located in the offshore locations in other jurisdictions, and this is why there has come a paradigm shift in the handling of the data, which we are supposed to discuss. Now data is completely electronic, unlike previous times when data was physical. Now it is in the cloud, now it is voluminous, unlike previous times when data in files or data in repositories were kept or stored. Some empirical statistics to to make you understand the magnanimity of this issue. The predictions came very early, when a widely watched measurement of internet usage and growth gave the following predictions in 2011, that global IP traffic has reached the zettabyte threshold, and it is going to increase 8-fold over the past 5 years. It will increase 4-fold over the next 5 years, right? And overall IP traffic will grow at a compound annual rate of 32% from 2010 to 2015. This was predicted in 2011, and since then it is phenomenally increasing. The overall data growth, or overall traffic, be it IP traffic or for that matter the exchange of the data, is growing phenomenally. Well, when it comes to protection regime on information assurance in India, we have first and foremost constitutional law, and I will definitely like to bring to your notice that this is a law, or this is a basic document which is referred while making any law in the country, which is a grand norm. You may say it is a grand norm, or more technically that constitution ought to be obeyed while making any law is the grand norm of the country. So, we have some constitutional tenets which come very handy, or which are very important when it comes to information assurance regime. Then we have contract law, and since I told you that when trade happens even between different countries, or when even inter-country trade happens, what happens? The contractual arrangements are made, and during the contractual arrangements, the exchange of data as well as its storage and protection and processing norms are being set out clearly, right. So, contractual laws are also very important. Then Information Technology Act of year 2000, which I just discussed, naturally it is also something very important, because it is the basic law which has recognized and defined the meaning of data as well as sensitive personal information, and has also let down certain provisions which do have some mechanism to address the issue of data leaks, or address the issue of data exchange without the consent of the person or its processing for that matter. Then we have Indian Penal Code, which has now been replaced with the new laws in 2024. We have got Bharatiya Dand Sahita now, which have equal provisions, or probably will have the equal provisions. I am yet to read the new provisions of the Bharatiya Dand Sahita. There are self regulations which I was mentioning earlier, that when it comes to trans-border data exchange, we had the self regulations or industry standards which probably were invoked, or which were invoked and which were considered at the time of trans-border data exchange, because our law was silent on it, but industry standards as per the best practices and the laws prevailing in other countries were molded and made in the country, and they were applied to determine the data exchange or transborder data exchange. And then intellectual property laws also, that is IPRs, they also are important when it comes to information assurance, because some of your information may be subject matter of intellectual property, and you will not allow somebody to use it like this, or you may not like somebody to free ride it without your consent. So these are the set of laws which do have relevance and significance and application when it comes to information assurance in India. Key developments in data protection regime in India, I have for your ready reference, I have provided the different stages as to how this law has evolved over the period of time in India. I recall that the first ever personal data protection bill was brought in India in the year 2006, right, and unfortunately the bill did not see the light of the day, as it had several flaws in its language per se, and the policy choices were not very great in this data protection bill of year 2000. Then between mid 2010 and September 2011, the Department of Personnel and Training and the Ministry of Law worked on several versions of a draft privacy bill. The bill on the right to privacy was drafted in the hope of curbing the growing trend of unbridled surveillance and to ensure that there are legal mechanisms for safeguarding privacy to balance the concerns of both individual privacy and state security. But even this did not get passed, or did not come. In 2012, specifically in the January of 2012, the Government of India established a committee of experts on privacy chaired by Justice A.P. Shah to review international best practices on privacy and recommend a framework for a privacy legislation in India, right. And followed in 2018, personal data protection bill was brought under the leadership of Justice B.N. Krishna committee, who himself later on criticized the bill tabled in the parliament, which faced vociferous opposition from the opposition parties in the parliament, and a parliamentary committee was constituted to look into the bill, but again it failed miserably and it did not turn into a proper law at the end of the day. And what actually turned into a proper law at the end of the day is the 2019 Digital Data Protection Act, right. Digital Data Protection Act bill was tabled in 2019, then lot of developments took place. This finally got the assent of the president in 23 and became a law, which is a Digital Data Protection Act of year 2023, right. So this is the operative position or operative law in the country, that is Digital Protection Act of 2023. So far as the constitutional law is concerned, viewers, let me tell you that there is a constant conflict when it comes to privacy and when it comes to state rights. Like we have on the one hand rights available to the state to put some reasonable restrictions on our freedom of speech, expression, etc. On the other hand, the same constitution law confers us fundamental rights in the form of freedom of speech and expression. So this constant conflict between right to privacy on the one hand and the right to know on the other, which is a species of right of freedom of speech and expression, is there in the constitutional law, and article 301A and is there to be read by the viewers if they want to read and see this conflict. But article 19 of the constitution also is handy, article 21 is also handy here, or you may say also important here, of the Constitution of India. Then it comes to contract law. Well, under the contract law, agreements are made, and agreements are entered into, such as non-circumvention agreements, non-disclosure agreements, user license agreements, referral partner agreements, etc. are entered into by the parties, which contain confidentiality and privacy clauses and also arbitration clauses. So these referral partner agreements contain confidentiality clauses. Licenses, user licenses also contains terms and conditions. Non-disclosure agreements, non-circumvention agreements are entered into. The business process outsourcing units which are coming to India and they do the business in India, they are supposed to implement processes like these standards which are on screen: BS 7799, ISO 17799 standard of information security management, which restrict the quantity of data that can be made available to employees of PPO. Then government has mandated implementation of security policy within the government in accordance with information security management system. In addition, computer security guidelines have also been issued for compliance within government, right. Now coming to Information Technology Act of year 2000, it is considered most comprehensive. We have constitutional law, some provisions are there. We have contract law. There are several manifestations of contracts like user contract or user license agreement, circumvention contracts, confidentiality contracts, non-disclosure contracts. But this Information Technology Act or the IT Act of year 2000 is the most comprehensive, because the concept of data protection was initially not envisaged in this act when the act was passed, but later on it was included and it has got its place and definitions have been provided. The major provisions dealing with data protection or data privacy, or you may say information, under the IT Act of year 2000 are section 43, 43A, 72 and 72A, section 79, right. These are the sections which are relevant sections under the IT Act of year 2000 of India, which are pertaining to information assurance: 43, 43A, 72, 72A and 79. So let us quickly talk about all of these and rapidly talk about all of these. When it comes to 43, penalty and compensation for damage to computer system etc. has been provided under 43, and if any person without permission of the owner or any other person who is in charge of a computer system or a computer network accesses or secures access to such computer system or computer network or computer resource, downloads, copies, extracts any data, right, then penalty is provided under 43 of the Information Technology Act. So any person who is not the legitimate owner of the computer system or a computer network, if he accesses and downloads, copies, extracts after having secured the access any data, then he shall be held liable under this act, and the penalty is there under this act, right. I will not read the entire section. Now 43A, another section of the IT Act, which provides for the compensation for failure to protect data, where a body corporate, and this section is pertaining to specifically pertaining to body corporate. When a body corporate possessing, dealing or handling any SPD, sensitive personal data or information in a computer resource which it owns, controls or operates, is negligent in implementing and maintaining reasonable security practices as prescribed under 2011 rules, SPD rules, right, then the body corporate has to pay damages for the failure to protect data, and the damages may go up to the tune of 5 crore rupees. Then section 72 is there, breach of confidentiality and privacy. This reads that, save as otherwise provided in this act or any other law for the time being in force, any person who in pursuant of any of the powers conferred under this act, rules or regulations made thereunder, has secured access to any electronic record, book, register, correspondence, information, document or other material without the consent of the person concerned, if he discloses such electronic record, book, register, correspondence etc. to any other person, he shall be punished for a term which may extend to 2 years or fine which may extend to 1 lakh rupees. So the point is, if you have been entrusted with some information by anyone or some document, some correspondence, some electronic record or a book, and if you without the consent of that person discloses such electronic record to some other person, then this is a breach of confidentiality and you may be held liable and penalized for 2 years or for 1 lakh rupees of fine or with both, right. 72 under the act provides for the punishment for disclosure of information in breach of lawful contract. So if you have entered into a contract with the with the consumers, Nowadays e-contracts, rampant e-contracts are being entered into by the platforms, by the online companies, e-commerce giants, etc. If they violate the terms of the agreements as entered by them, or do the breach of a lawful contract as entered by them, there is a punishment provided to them for the disclosure of information provided by you to them, and under 72 they shall be made liable. 79 though provides some intermediary exemptions or a safe harbor to them, but that does not mean that they can do whatever whimsically, or they can do whatever they want to do. This has some exemptions or immunities available for the intermediaries who take data from you or who host your information, right. But if they do anything which is without your consent, then that is problematic. So, no intermediary is allowed to do anything which is without your consent, even with your data, though they are supposedly, or they are primarily responsible for hosting your data or your information to the third parties, but or third party information data is hosted by them, but they cannot be completely immune, or they no blanket immunity is to be made available to them or can be available to them, right. So, so far as the shortcomings of this act is concerned, you must be wondering that it has lot of sections 43, 43A, 72, 72A, 79, but yet there are some shortcomings in this law, and that is why this law was termed as inadequate law or not comprehensive law. So, this law does not or did not provide any recognition to the preservation and protection of data in the preamble. This law is basically data is outside the scope and purpose of the IT Act, because predominant purpose of the IT Act is e-commerce and crimes or contraventions, right. Data is outside the scope and purpose of the IT Act. 43 is only a punitive provision and protects data in a very limited sense. It provides protection only to data processed and stored in electronic form. It does not provide protection to data which is non-digitized, right. It is a mere recourse to compensate the individual. It does not address data protection in its entirety. It does not assign a higher level of protection to SPD. Then 43 also places liability on an intermediary. However, intermediary sued under this 43A, like a body corporate, which may be a platform, which may be a service provider, get immunities under 79. So, it gets neutralized, right. In order to make a person liable under 72A, it has to be proved that the person disclosing the personal information did so with an intention to cause wrongful loss or wrongful gain. So, mens rea has been made the benchmark here, which should not be the benchmark, because every person should be made it must be the obligation of every person to keep others information or the data intact, and they must not disclose it. Then meaning thereby that mere proof of damage is insufficient, right. When it comes to Indian Penal Code, the remedies provided in the IPC are inadequate in a transnational context. The remedies provided in the IPC do have their application maximum to the territory of India. They do not have the transnational application, and in the case of data, as I said, that the data is new oil and lot of data is being exchanged, transborder exchange is taking place, IPC becomes weak and bleak. The meaning of movable property is unclear as to whether it extends to include intellectual property or information and data. Then the cost, delay and inconvenience associated for foreign national bringing actions in Indian courts offsets the availability of recourse, right. Self-regulatory measures are also in place or have been in the place. What are those self-regulatory measures? Data exporters have a rigorous process for selecting the BPO. Focus on the identification and sharing of the best security practices. Security and legal teams are appointed to impart training to BPO employees. Then internal and external auditing takes place. They conduct and review disaster prevention mock drills, strict confidentiality and security arrangements are entered, requirement of compliance with international security standards, masking of sensitive information takes place only at the behest of data exporter, right, and thorough background check of potential employees. So, these are the self regulatory measures which are in place or have been in place in India, which do provide some remedies or some procedure for the protection and upkeep of the data. Then biometric security devices, palm and retina scanners, limited internet access to preclude malware and viruses to the employees, prohibition on tools like pen drives, mobile phones in the companies, then removal of the hardware devices, creation of Data Security Council of India by NASSCOM, and NASSCOM 4E initiative, education, engagement, enactment, enforcement. So, these are some self regulatory measures taken by the industries in India, which are in place or which have been in place to provide some regulatory framework in relation to data or in the context of the information assurance, right. Now, Digital Data Protection Act, which is you may say the new act and which is the latest act. It is first ever privacy act to strike a delicate balance between individual rights and organizations' legitimate data protection needs. So, we all understand that it is individual's right to keep his information safe, but on the other hand, organizations also have a legitimate right to process your data, because you have to every day deal with these organizations and they provide you a lot of services, and you cannot nowadays with in this age of revolution, digital revolution, you cannot stay without using these organizations, these platforms or their services, right. So, they have a legitimate requirement of data processing, because they have to process, they have to sustain in the market. So, this act strikes a delicate balance. The primary purpose of this act is to regulate the processing of digital personal data and respect individuals' right to protect their data, while recognizing the necessity of processing and using such data for lawful purposes. Well, this act also recognizes that for lawful purposes there may occur a necessity of processing and using anyone's data, and it allows certain agencies, organizations for the lawful purposes to access anyone's data, to process and use anyone's information or data. For example, for national security, for law and public order, for investigation, etc. Your phone may be your passcode may be broken, your phone may be accessed, or details in your phone may be accessed. The language employed in this act is simple and straightforward, ensuring easy comprehension for all. Moreover, the act aims to establish a comprehensive legal framework to govern digital personal data protection in India. Well, unlike the previous law or regulations, this act has a simple and straightforward definition, easy for comprehension of all, and it governs very beautifully the digital landscape or digital personal data landscape in India. The Act's provisions covers personal data in digital format, including both data that is digital originally and non-digital data which subsequently may be digitized. So, this is a very beautiful feature of this act, that it applies to digital data as well as non-digital data which is subsequently digitized, right, and it makes it a unique, because no law or no preceding law prior to it or no regulations prior to it extended the application to non-digital data, right, which is why this law is called comprehensive and deemed comprehensive. The Act provides for the processing of digital personal data in a manner that recognize both the rights of individuals to protect their personal data and need to process such personal data for lawful purposes for matters connected therewith or incidental thereto. The Act protects digital personal data, that is the data by which a person may be identified, by providing for the following. This act has a very balanced approach, because it puts some obligations on data fiduciaries, on those persons who process your data, who take away your data, or they are called data fiduciaries because in the fiduciary relationship you share your information with them. you have that trust bestowed and repose on them, and you share your information with them. But if that data fiduciary processes it for a wrong manner, uses it for wrong manner, discloses it further, leaks it further, then it is problematic. But this law puts obligations on data fiduciary and also puts some rights and duties of data principals. And in the case of breach of the obligations of the data fiduciaries or duties of the data principals, it penalizes also, right. So the act also seeks to achieve following things. It has introduced data protection law with minimum disruption while ensuring necessary change in the way data fiduciaries process data. It has enhanced the ease of living and ease of doing business. It enables India's digital economy and its innovation ecosystem. The act is based on the following 7 principles. Well, these principles are very important for you to understand, on which this act relies or revolves around. Principle of consent, lawful and transparent use of personal data, right. No data fiduciary can take away your data without your consent. They have to take your data in a transparent manner and use it lawfully. They cannot use it unlawfully, they cannot take it without your consent. So this principle of consent, lawful and transparent use of personal data is the cornerstone of this law. Then the principle of purpose limitation, that the data fiduciary shall use your personal data only for the purpose specified at the time of obtaining the consent of the data principal. So there is a usage, but limited usage allowed for the data fiduciary only in the specified manner which you declare to the data principal initially at the time of taking of the data. The principle of data minimization, well, this is again very important because we are witnessing that data is increasing meteorically. So collection of only as much personal data as is necessary to serve the specified purpose. So when it comes to personal data, these data fiduciaries have the obligation to collect minimal and necessary personal data. Then the principle of data accuracy, ensuring data is correct and updated. So again, fiduciaries have the obligation that they have to ensure that the data is correct and it is updated. The principle of storage limitation, storing data only till it is needed for the specified purpose and then erasing it, not keeping it forever. And then the principle of reasonable security safeguards. So like reasonable security practices of 2011 about sensitive personal information, SPD rules, they also this law is also based on principle of reasonable security safeguards. And the principle of accountability through adjudication of data breaches and breaches of the provisions of the bill and imposition of penalties for the breaches, right. The act has few other innovative features. This act is consigned as SARL, that is simple, accessible, rational and actionable law, as it uses plain language, contains illustrations that make the meaning clear, contains no provisos. So it is not a very complicated law, any commoner may also read it and understand it, and it has minimal cross references that you need to refer to section 1 of this act while understanding section 20 of this act or another section that is 30 of this act. So there is a minimum cross references which makes it simpler for the any layman to read it or any individual to understand it, right. Then this law is again very important because it has used the word she instead of he, and it acknowledges women in parliamentary lawmaking by using the word she. The act provides for following rights to the individual: the right to access information about personal data processed, the right to correction and erasure of data, the right to grievance redressal, the right to nominate a person to exercise rights in case of death or incapacity. So these rights are very important, that any person may get the data or information corrected or erased. So this is something unique about this act, which was not present earlier. Even standards or regulatory measures were silent about these things, that nobody can or could correct or erase once he or she shares the information. But now you have a option of correction and erasure, right. The right to grievance redressal is also there. You may apply for the redressal of the grievance, and the data fiduciaries have to necessarily do it, because there is a data protection board to whom you can approach in a hassle free manner here, and they immediately take action against the data fiduciaries in case of violation. The Act also provides for following obligations on data fiduciaries: to have security safeguards to prevent personal data breach, to intimate personal data breaches to the affected data principal and data protection board. So, a notification or principle of notice is also very important. Principle of notice, that whenever the data leak or data breach will happen, the affected data principal will be notified, as well as the data protection board will be notified, to erase personal data when it is no longer needed for the specified purpose. So, these data fiduciaries should not keep the data with them forever. They are supposed to erase it when it is not needed anymore. They are supposed to erase personal data upon withdrawal of consent. So, in case if you have withdrawn your consent to use your data, they are supposed to erase that. To have in place grievance redressal system, they also are supposed to have their own grievance redressal system by purview of this law. So, any data fiduciary, be it a social media platform or a significant social media platform or a web browsing service provider or a internet service provider, right, they are supposed to have their own grievance redressal system, and they are supposed to appoint an officer to respond to the query for data principals, and they are supposed to fulfill certain additional obligations in respect of data fiduciaries notified as significant data fiduciaries, such as appointing a data auditor and conducting periodic data protection impact assessment to ensure high degree of data protection. So, now this law has brought international best standards, right, wherein data auditing will take place, periodic data assessment to ensure high degree of data protection has to take place, and they have to appoint the officer, dedicated officer to do all these things, right. The Act safeguards the personal data of children also. The Act allows a data fiduciary to process the personal data of children only with parental consent. We all know that children nowadays are using social media or other platforms, and they are very vulnerable to any kind of a violation or any kind of a crime to happen, online crime to happen against their person, right. So, in that case, parental consent has to be obtained by the data fiduciaries while interacting with the children. The Act does not permit processing which is detrimental to well-being of children or involves their tracking, behavioral monitoring or targeting, advertising, etc. The exemptions are also there in the Act, which are as follows. For notified agencies, I told you in the beginning that for the lawful purposes, in the interest of security, sovereignty, public order, etc., some notified agencies are allowed to use or process the data. For research, archiving or statistical purposes, the data may be used. For startup or other notified categories of the data fiduciaries, data may be processed to enforce legal rights and claims, to perform judicial or regulatory functions. Data may be used to prevent, detect, investigate or prosecute offences. The data may be processed or used to process in India personal data of non-residents under foreign contract, for approved merger, demerger, etc., and to locate defaulters and their financial assets. These are some exemptions which are available to some notified agencies, and in the context of some special needs or necessity, and in emergent situations, anyone's data or data principals data may be used or processed, but not beyond these stipulated exemptions, not beyond these stipulated exemptions. Nobody is allowed beyond these stipulated exemptions to use or process your data, right. So, this is all about the data protection regime, or you may say about the information assurance law in India. So, we quickly have a recap, or you may say we will quickly have a recalling of the important points of this particular lecture. Let me quickly tell you that I started with the Information Technology Act, and I told you the important provisions of the Information Technology Act, section 43, 43A, 72, 72A, and then finally 79. Then we went on to discuss constitutional tenets, and I forgot to discuss Puttaswamy. I must tell you that Puttaswamy judgment is one judgment which upholds the privacy as a fundamental right, and it also provides mechanism for deciding what are the contours of privacy, what constitutes privacy. So, Puttaswamy and its ratio is to be applied while legislating by the lawmakers in the country. We also discussed constitutional arrangement, article 301A. We also discussed article 19, 21 of the constitution. In this lecture we also talked about contractual arrangements, where I told you that e-contracts are taking place on the click of a button. There are NDAs, non-disclosure agreements are being entered into by the parties. There are non-circumvention and non-disclosure agreements are being entered into by the parties, and user license agreements are being entered into by the parties. So, we have set of laws including constitution, IT Act, contract law, then IPC, which also defines movable property, but it is unclear whether under the definition of movable property data will come or not. But since it is being flown and exchanged and transcending boundaries, right, so naturally it must be must fall under the definition of movable property, and all provisions relating to movable property must get attracted when any breach relating to or when any right of a property gets violated, right. And then lastly we saw the Digital Data Protection Act of 2023. I explained the key highlights of the Data Protection Act in a very simplistic manner to all of you, wherein the very specific highlights are that this Digital Data Protection Act of 2023 is the most comprehensive one, because it caters or it covers or it envisages digital as well as non-digital data which is subsequently digitized in its sweep, or you may say it legislates on both the issues. Then the terms used like data fiduciary and data principles are also not very derogatory. In the earlier bills starting onwards since 2006, then later on in 2011, then 2018, the data principles were called the data subjects, but ideally they are not the data subjects, they are the owners of that information. So, there was a terminological error in all those acts since the beginning, but that has been rectified with, and that has been done away with the introduction of these respectful terms like data principle. So, we are the data principles, we are becoming victims at the hands of these data masters, or you may say data fiduciaries, right. And again data fiduciary is a term which is very important, right, because data fiduciary means to whom you are entrusting your data, and you have some sort of trust bestowed or reposed in that particular body corporate or that entity to whom you are giving it, and they are not supposed to misuse, not supposed to indiscriminately process it or use it beyond your consent and beyond the specified purposes. So, this law to my understanding is going to serve the great purpose, and it has ended the long wait of almost 20 years since 2006 when first data protection bill was brought, and since now it is in place, it is to be seen how this law can be applied by the data principles as well as data fiduciaries, and it is also to be seen in the future or in the years to come how many disputes will arise under this act, which will reach to the courts of law, and some judgments will get delivered on the basis of this law, which will create a strong jurisprudence in this particular context, right. So, we have to end this lecture, we have a very happy development, that is the Digital Data Protection Act of 2023. Let us see how the courts are going to react and how the courts are going to attract this particular law. So, with this note, I take your leave, and I thank you, all of you, for patient listening. Thank you very much. I am looking forward to meeting you again with some more fascinating lectures in this series called Law, Science and Technology. Thank you very much.